Um, we want to thank all of you for joining us this evening, our Portland Elder Care Council, for today's education event. And I was telling the group earlier, if you have any questions as we go through this, feel free to type it in the chat box, wave your hand, get our attention. We'll make sure that we answer all of your questions. I'll get into the presentation in just a second. At the end of the survey, or at the end of the presentation, I will have a survey in the chat box that you can fill out. Let us know how we're doing, or if you want more information. And we'll also put a link into our next event as well. So keep that in mind. Before I introduce the presentation, am I missing anything from my other council members? Okay, great. All right, I'm going to screen share here just a moment to get our slides up. And all righty. So first off, a little bit about us here at the Portland Elder Care Council. We are a group of volunteers that are dedicated to helping individual members and families in our community deal with long-term care planning issues, elder estate, whatever the case may be. Our mission is to really help our older adult population, their caregivers, their families with education and resources so that you know what to do, when to do it, and how. Myself, I'm the senior placement specialist of our group. I'm also co-director with Kelsey here. She's a realtor and she specializes in helping seniors. We also have Whitney, who's our right sizing coach, Jamie, who is a licensed clinical counselor. Mariah Hurlbert is our money guru. Melissa is our aging life care manager, occupational therapist. We also have Suzanne, Rowe, and Jennifer Trundy. These two are going to be presenting our event today. Suzanne's a guardian and fiduciary specialist, and Jennifer Trundy is our elder law attorney, an elder law estate or estate specialist. And then we have Nora King, who is our Medicare plan specialist, and she will be delivering our next presentation. So now you know all the members of our little council here. And we want to introduce today's topic. Some of you might have been on for part one of this series, Get Your Docs in a Row. We had that back in June, and that was all about the money side of getting your paperwork and your affairs in order. So today, this is all going to be about your healthcare representative, guardianship, and how all of that works and the importance of getting those in place appropriately. So I'm going to go ahead and let the girls take it away. Are you ready for me to switch slides, whoever's starting? Perfect. All right, go ahead.
I suppose I should unmute to be able to do that. My name is Jennifer Trundy. I am an elder law attorney here in the Portland area. And a lot of people ask what elder law is. Elder law is estate planning plus long-term care planning. Elder law attorneys help clients protect themselves, their families, their estates, and be able to make those different changes. The other thing is that there are great estate planning attorneys out there, but what they do is they focus on what happens when you die, not what happens at the end of your life. Which is what elder law attorneys do. We do all of the estate planning side, then we do the time from between the time you've done your estate plan and you pass away, and then we can help with probate and trust administration. So people are living a lot longer these days than they used to, and which is great news, but we're not necessarily living better lives. So we want to be able to plan for our best life and the best end of our life so that we can handle it and our families can enjoy their time with us instead of being stressed out trying to take care of details that could have been handled sooner. You can go ahead and switch that. Suzanne?
Yep, I'm here. Sorry. Okay. Hi, I'm Suzanne. I am a professional fiduciary, guardian, and conservator. And the word fiduciary is derived from the Latin word fiedere, which means to trust. So a fiduciary is somebody that you have given the authority to be a decision maker when you are not able to make decisions for yourself. So some of you might think of a fiduciary as somebody that's in the investment or financial world. That too is a fiduciary. It's kind of a broad term. But in the terms that we're talking about today, we're talking about guardianship as a fiduciary. A professional fiduciary in Oregon must be nationally certified, and that allows a court to appoint a fiduciary to act on that person's behalf. And so today we're going to be talking about a fiduciary and guardianship in healthcare and medical decisions.
So what is a guardianship and a conservatorship? Last time we talked, which some of you were here in June and some of you weren't, we talked about conservatorships and how to avoid them. This time we're going to talk about guardianships, and the easiest way to describe that is a guardianship is a court supervised proceeding to manage the personal affairs of an incapacitated person. And by incapacitated, that could be that you can't physically take care of your own needs and can't make decisions on your own behalf. Conservatorship is a court supervised proceeding to manage the financial affairs of an incapacitated person. So oftentimes we'll do both. Sometimes we only need a guardianship if there really aren't any funds that the person has available. But in either case, these are called protected proceedings, and they are to take care of people who can't take care of themselves. So guardianship is for the person, and conservatorship is for the estate or the finances. So to recap from last time, to avoid a conservatorship, if you cannot make decisions for yourself financially, you need to have a durable power of attorney. A durable power of attorney lets somebody make financial decisions for you, including any legal decisions, being able to apply for Medicaid on your behalf or other government benefits, and be able to spend down to qualify you for Medicaid, which is another thing that elder law attorneys do. On the Portland Elder Care Council website, there, I believe, is a link that you can either request a recording or download a recording for the Get Your Ducks in a Row Part 1, if you want to take a look at that. So one of the things to prevent a guardianship is to have somebody who is your health representative if you can't take care of yourself. We do that in Oregon through an advance directive. An advance directive is a statutory form in the state. It is a medical directive that combines a living will and a durable power of attorney for healthcare into one document. When something's a durable power, it means it survives incapacity. It's a statutory form, and you don't need to have an attorney prepare it. We do it for all of our clients that we do estate planning for as kind of an extra so that we are sure they have it. It does need to be notarized or witnessed by two people who are not named as healthcare representatives and are not an attending healthcare provider. So if you decide that you want your son and daughter to be your health representatives, they can't sign as witnesses, but we can have a notary do it for you. What's included? So what's included in an advance directive is the appointment of a healthcare representative. That is the durable power of attorney for healthcare. It allows another person to make healthcare decisions for you when you cannot. It's the healthcare instruction to the physician, which is the living will part. And that's going to express your wishes with regard to life support and tube feeding. And I think everyone over 18 should have an advance directive and a durable power of attorney for finances. My girls are 25 and 27 and both have had them since they turned 18. Many times as we age, people say, oh, you only want me to do these documents because I'm old. And I think everybody, no matter what their age, if they're over 18, need to assign who they want to have making decisions for them. I don't know how many of you remember the Terry Schiavo case in Florida, where it was a newlywed who was in a vegetative state, and her new husband, she was very newly married, and her parents fought over if they should continue life support for her. It was a really, really tragic situation and ended up being politicized, and the governor stepped in and did a stay, and it was just a mess. And I would hate to have anybody's family members have to go through that and be in the press on a weekly basis.
Jennifer, I have a question.
Sure.
And I might have missed this, but let's say I get into a car accident.
Mhm.
Does the decision-making process automatically go to my husband or no?
No, it does not go to your husband, does not go to your kids. It does not go to anybody unless you have an advance directive. Now, if you have an advance directive in place, it allows them to act if you're unable to act on your own behalf. So as far as making decisions regarding life support and tube feeding, just the fact that he's your husband doesn't mean that he can make a decision for you.
So who makes that decision then?
Sometimes it doesn't get made and you just linger. It's not a good situation. Okay, and that is also something that comes up. I currently have a case where a family, the dad has Alzheimer's and he needs to go into a lockdown memory care unit and they don't have an advance directive or a power of attorney. So we're having to get a guardianship for him. His daughter's going to have to be the guardian for the rest of his life because he can't make decisions in the memory care community that he wants to move into or his wife wants to move him into, won't take him because he can't admit himself because of his lack of capacity. So we have to have that guardianship in place. So.
I have a question on that too, just to clarify, because this comes up quite a bit, specifically around memory care. The guardianship only becomes a factor when this power of attorney is not in place, correct? Or are there other times when guardianship might need to be addressed?
Oftentimes there's times where guardianships need to be addressed. Sometimes it doesn't have anything to do with going into a facility. A guardianship could be someone who needs medical attention. We have it come up often that somebody will have a urinary tract infection and it creates dementia type symptoms. Suzanne's nodding. And oftentimes we can get an emergency guardianship, which isn't easy, just to get them to go to the doctor because they'll refuse to go. And without having that guardianship, nobody can make them go. Like I couldn't make my mom go to the doctor. And if sometimes that person doesn't have dementia, it's the urinary tract infection that's causing the dementia type symptoms. So in a case like that, if there's nobody that can make a decision for them, if they've not appointed anybody as their healthcare representative, then nobody can make them go to the doctor or take them to the doctor or sign for anything. So it's really important to have that paperwork in place. I had a neighbor in Florida whose daughter was 19 and was in a quad accident, one of those little, four-wheelie dune buggy type things that flipped over. She was 19 and the hospital couldn't tell her family what her medical condition was because they didn't have permission. And Florida is a lot tighter on it than Oregon is. But they're, once your child turns 18, they're their own person and you can't make decisions for them anymore. So it's very important to have an advance directive, a power of attorney, and then we also provide a HIPAA waiver, a blanket HIPAA waiver for people. So.
Thank you. That's super helpful. Are you ready for me to go to the next?
We can switch over unless there's more questions. Okay. So on your advance directive, you're going to make some decisions regarding end of life care. It's not a fun piece of paper, but it's a relief to have it done, is how I usually describe it. You can either decline all tube feeding and life support, or you can make decisions depending on what specific situations you are in. So this is actually from the statutory form. That's the statement regarding the end of life care. When you fill out your advance directive, you basically have two choices. You can choose A or you can choose B. If you choose A, it's basically saying, I do not want my life prolonged by life support. I also don't want tube feeding as life support. I want to die naturally. If you are in any of the medical conditions listed below, which are listed in Part B, and that is close to death, permanently unconscious, you have an advanced progressive illness, or you have extraordinary suffering. In those cases, and I jokingly say that if you choose B, you get to pick your own adventure and go through, and it has individual lines. Yes, I want life support. No, I don't want life support. Or I only want it if my healthcare representative or my healthcare provider, so your doctor, recommends it. And it'll say that about tube feeding as well. Yes, I do. No, I don't, or only if my doctor recommends it. And it goes through that for each of those conditions. So if you're close to death, yes, no, maybe. And I've had people that have been very specific in what they want. If they're close to death, yes, they want it, or they don't want it. Extraordinary suffering, no, they don't. It's very, very involved because people have different choices of how they want it. I had one lady who wanted life support but no tube feeding. So that's a good thing for parents to, or for families to know. The other thing we do is we provide I think it's about a 10-page worksheet that people can use if they want to, but it's to provide extra information, and it goes into how do you feel about transfusions and pain meds and being a donor and what type of donor do you want to be. And it's not a legal document, but it is a worksheet that family members can use when they're trying to make those decisions in that case. So any questions on that?
I have a quick question, Jennifer. It's Jamie.
Sure.
About extraordinary suffering. How is that determined? Because it seems rather subjective. Is it the medical provider who makes that decision?
It is. It's if your healthcare provider and another knowledgeable healthcare provider both confirm that you're in an extraordinary suffering situation. And usually if somebody is at that point, they are on IV pain meds. They've gotten to the point where they're so medicated that they may not be able to breathe on their own anymore, because a lot of pain medications do suppress breathing and respiratory. So they will often be in that kind of a situation where they're just at that point. I know my late father-in-law was at that point with cancer. He just was suffering to the point where he couldn't really make any decisions or do anything because of the pain. So any other questions? It's a fun topic, guys. Okay. So, and a lot of times what I'll hear is, but I have a POLST. Do I need an advance directive? And they're two very different forms. A POLST is a portable order for life-sustaining treatment. It used to be called a physician's order for life-sustaining treatment, but they changed it a couple of years ago. It's also referred to in a lot of states as a DNR, or do not resuscitate. And it's usually on a bright pink piece of paper. You'll see this, the people will stick it to their refrigerator, or it'll be on the first page of their chart or second page, sometimes in the hospital, or it'll be hanging on their room at an assisted living or a skilled nursing facility. Might be attached to their bed. And basically what that's saying is, if I quit breathing and my heart stops, so if I'm in a place where I need to be resuscitated, I used to be a basic life support instructor and taught a ton of people how to do CPR. You don't do CPR on a living person. You do CPR on somebody who is essentially dead. That's when a POLST comes into play. It's, do you need to be resuscitated? Do you want the EMTs beating on your chest? Do you want that to go on? And some people don't, especially when you get older and more frail. I have done CPR several times, and every single time I've broken people's ribs. And if you are in a fragile health situation that you may or may not live, a lot of people don't want to have CPR or any other resuscitation, because the recovery from it can be really rough. So this is something that can only be done by your doctor. If you want one, you need to ask your doctor for it, though oftentimes if you are in a health condition, if you have like terminal cancer or Parkinson's or end stage life situations, your doctor will usually recommend and say, hey, do you want a POLST? And they'll have this conversation with you. And it's something you fill out. It has to be signed by a doctor to ensure that your patient, your wishes are carried out. It is not the same as an advance directive. An advance directive is for when you are alive and you're trying to make decisions on what's next. A POLST or a DNR is for really when you're dead, but you're right at that edge and could be brought back. So it's a very, very different document. Is there any questions there? No. That's what it looks like. It's bright pink. And you can see it says right there, unresponsive, pulseless, and not breathing. Do you want CPR?
In Washington, isn't it green?
Different states do it different. It's bright orange in Florida.
Okay.
Yeah,
I
a lot,
didn't
and
know.
some states have it in a little cylinder, and they tell you to keep it in your freezer so that the EMTs know in that state to go look in the freezer. People have said, I'm just gonna tattoo it across my chest, do not resuscitate. That's not a legal form. They can't do that. Like, they can't pay attention to it. If your chest said, do not resuscitate, they rip open your shirt to start doing CPR, they would just keep going. Which is,
Weird that they would keep it in the freezer.
I think it's so it's in a place that people can find it, like that's just the thing. If an EMT goes into the house, they check the outside of the freezer, the inside of the freezer, and next to the bed.
Seems
I know.
common.
Yeah, so anyway, so we can flip past that. And we're going to go into a case study with Suzanne. She's going to tell us about a hypothetical person that she's worked with. You're muted, Suzanne.
Sorry. We're going to talk about Alan. If you could go back to the previous slide, Bess. Alan was a 92-year-old gentleman, and he was living alone in his home and doing quite well for a while. And his neighbors didn't see him around for a couple of days, so they made some contact with Alan, and they found him on the floor and called 911. He was taken to the hospital and admitted, and he was suffering from dehydration and malnourishment. So he wasn't drinking enough water. He wasn't finding food for himself. He was refusing Meals on Wheels. He wasn't getting to the grocery store. He was no longer driving, and he didn't reach out for any help. So when he was admitted to the hospital, they took him in and got him shaped up, and he was admitted and rehydrated him and got him some good food for a while. And while he was in the hospital, it was determined that he had frontotemporal dementia, which is a form of dementia. Because of his diagnosis of dementia, it was determined by his doctors that it wasn't safe for him to be living at home alone any longer. So he wasn't able to provide food for himself. He wasn't able to provide his activities of daily living. He needed help and assistance in every facet of his life. So returning home wasn't an option for Alan. Next slide, please. So he never did an estate plan. He never designated a healthcare representative. And he was divorced and living alone. He was unfortunately estranged from his children, which sometimes happens. So there was nobody really present and current in his life that was really there to help Alan make decisions or to come in and step in and act on his behalf. So after a few weeks, he was ready for discharge. However, as Jennifer talked about before, memory care or any other type of adult foster care or adult care community wouldn't let him admit himself because of his dementia diagnosis. So the only way that was going to happen was to have a guardian put in place. And without his children involved in his life and no siblings or other family members to step in, they had to find a fiduciary to step in and act as Alan's guardian to help make these placement and ongoing medical decisions. Once the guardianship was in place, and that's a whole process, which is probably a whole nother presentation in and of itself. So I'll kind of skip over that whole process. But now that the guardian was in place, so the hospital social workers and other people like Adult Protective Services may contact somebody like myself, who's a professional guardian, to step in and help somebody make decisions when nobody is there to make those decisions for him. So now with the guardianship in place, he could safely be admitted into the adult care community, memory care, or wherever the best placement for Alan was. Next slide, please. So he didn't have a healthcare representative. He didn't have any of the proper documentation in place. So the guardianship was necessary in order for Alan to live his best life. And so what the guardian can do to help him do that is, as we talked about, get him admitted into a appropriate adult care home. Can also provide clothing that he might need, any personal care items, those types of things. The guardian is also responsible for making any and all medical decisions on Alan's behalf. So that would include his ongoing medical care. It could include enrolling him on hospice if that was determined by his physicians to be the best course of action for his condition. It could also include and should include things like ongoing medical care, dental and vision, and making those appointments and following up and just making sure that Alan had the best care possible. Also, the guardian can manage assets in the state of Oregon under $10,000. But once you get over assets of over $10,000, then a conservatorship is needed. But as long as it's under $10,000, it's fine for the guardian to manage those assets. The guardian can also, in the state of Oregon, apply to the Social Security Administration to become Alan's representative payee, so that his Social Security checks could go to the guardian to pay for his ongoing care, perhaps also to make contribution to his monthly room and board at the adult care facility. So that's some of the things that the guardian can do. A guardian can also make pre-need funeral arrangements on behalf of Alan. So that could be an important piece. And some of these decisions that you're making for somebody that you're guardian for, it's always best to try to gather as much history from them or about them, maybe from neighbors or other people, so that you can make the choices that Alan would make and make them for him. So the best informed and surrogate decision-making choices that you can make on behalf of somebody else. You always try to want to follow what their religious beliefs are. You want to try to follow, personal preferences in that regard to honor what it is that Alan would do if he were making those decisions for himself. So the guardian must make medical decisions and personal decisions, and do what is right in the best interest of Alan on his behalf. There's certain things a guardian cannot do. A guardian cannot sell a home on behalf of somebody else. A guardian cannot access banking or investment accounts that exceed $10,000. And a guardian cannot sell somebody else's vehicle. I could not sell Alan's car with a guardianship. That wouldn't mean that I would have to have a conservatorship in place in order to do some of those things. And again, the guardian can be compensated with court approval with Alan's funds, and that is usually done on an annual basis. So even if the guardian is a family member, the guardian can still petition the court for guardian fees as a family member, as long as time records are kept and expenses and things like that to submit to the court for reimbursement. There's sometimes cases where you want to have a temporary guardianship put in place. A temporary guardianship is used when a person is in immediate need for a decision maker. The temporary guardianship sort of temporarily shortens the whole court proceeding process. So say if somebody needs to be placed on hospice immediately, a temporary guardianship might be necessary in a case like that. Or sometimes a temporary guardianship is used when maybe the incapacitation of the person is temporary. So as Jennifer described, somebody that has a urinary tract infection and has these signs of dementia, or making poor decisions and things like that, or needs the medical care that they're having some self-neglect issues. Temporary guardian might be used in that case to help facilitate in the immediate care of somebody, but then maybe after the 30 days, things are fine and the person has been restored to full capacity. And in that case, it's possible that maybe the temporary guardianship could be dissolved. So in a guardianship for a professional fiduciary, we're actually in the business of putting ourselves out of business, because what we want to do is bring the person back to capacity as much as we can, foster their needs and their care, and hopefully someday they would be able to act independently, make their decisions on their own, and no longer need a decision maker on their behalf. Sometimes this is the case. This is always what we aim for, especially in younger people, but sometimes it's not the case either. So that is all I have to say about Alan. Are there any questions?
So yeah, I was gonna say, there are some issues with guardianship. It's not a simple procedure. It's invasive. And I'm not saying this bad towards Suzanne, that's not this part of it, but if you have your docs in a row, if you have the paperwork you need in place, then you don't have to have a judge take away your rights, because essentially having a guardianship or conservatorship, the process is that you have somebody who petitions the court to say, hey, judge, this person can't take care of themselves anymore. You need to take away their rights to be able to take care of themselves and give them to somebody to take care of it for them. There is a very specific procedure. There's a petition that goes to the court, and it discusses why you're incapacitated, what, if you were running naked down I-5, which has happened, why you're incapacitated, what's been done, why this is the least intrusive thing that can be done, like what else has been tried. And it talks about your finances, and the conservatorship part goes even deeper into your finances. What banks your bank accounts are at, what do you own, all of that information, and it's all public record. So it's a very invasive process. So if you can have a few pieces of paper in place, it makes a huge difference to have your family not have to petition for your guardianship later. The process is that you petition, and then it goes to the judge, and then there's a court visitor assigned, which is a neutral party, which is kind of the eyes and the ears of the judge, that goes out and talks to the caregivers, the family members, if there are any, the neighbors, whoever they need to talk to get input on what the person's capacity is. And then they make a report and they submit that to the judge, and then the judge makes a decision. The person who's a guardian has to go through a guardianship training program. It's an online webinar type of thing to be able to, so the court can say, yes, this person's been trained, and you have to submit that to the court that it's been done. And so there's a lot of hoops to jump through, and it's not an easy process, and it's not easy on the family. And the person who is the guardianship is you're trying to get for the patient, so to speak, they're served. They get served by a process server. We use really nice process servers that understand that situation. It's a little different than if they're trying to, get you to pay back the $100 grand that you owe for, a car you stole or whatever. But the process servers go out and they deliver the packet of paper, and they have to serve the person specifically. There is a sheet in there. It's always blue, and it's always in big type, so that they can contest it and they can say, no, I don't want to have a guardian. But it's an involved process, and it's something where people are like, I don't want to think about it. I don't want a power of attorney. I don't want to do all of this. And by getting those documents done saves hundreds of hours of grief for the family. And if you don't have anybody to help you, you can choose to have appoint somebody like Suzanne when you're doing your power of attorney. I just did one the other day, and she's like, my family are flakes. I don't want any of them handling my money, and I don't want any of them making medical decisions for me. So she's going to appoint a professional fiduciary to do that for her, because she doesn't want her family to have to deal with it. We have it happen often. We're like, I don't want my kids to have to do that. They're going to fight. And so they appoint a professional. So it's not just in an emergency situation. Having somebody like Suzanne on your team is invaluable, because she knows what she's doing. And yes, there's a fee involved, but you only pay her for the time you use her. So it's a lot less stressful than having kids who are working and have kids and have everything else going on. And they're like, oh, and I got to pay mom's bills. And it's just sometimes easier just to be able to say, hey, you know what, let's have this professional do it. That's what she does. And it streamlines it. It makes things a lot easier for the family.
Plus the cost of filing for a guardianship and going through that, it's really expensive, isn't it, Jennifer?
It is. The average in the state of Oregon, I think right now is about $4,500. A power of attorney and an advance directive, $400, $500, somewhere in there. One thing that, since this isn't the power of attorney thing, but I will say, don't download a power of attorney online and fill it out. It's not going to give you the coverage that you need. Oregon power of attorneys are strictly construed, which means if it doesn't say your agent under power of attorney can do it, they can't do it. And oftentimes that can make a huge difference. I just had a family that if they had had a sufficient power of attorney prepared by an elder law attorney in doing Medicaid planning for that family, we could have saved the family about $380,000. And we couldn't do a thing because they didn't have a correct power of attorney. So.
I just want to add real quick that once you're appointed by the court as a guardian, you are responsible to make an annual report to the court about the protected person and their living situation, and are the needs being met, and any medical decisions, and are you taking them to the doctor. So the court requires that of every guardian, whether it's a family member or a professional like myself. So the court does follow and make sure that that all the things are being done properly for the protected person.
You're muted, Nora.
Unmute. You mentioned with a guardian or conservatorship, the information becomes public record. Does that open up somebody to identity theft? Isn't that a dangerous?
No, because they redact like social security number and birthday when the court scans it. They redact birthday, social security number, usually any bank account numbers. But when we submit our petitions, we usually just use the last 4 digits to identify, because if somebody has 5 bank accounts with US Bank, we need to have a way of identifying which is which. So so yeah, it's available to anybody who can view the court records. So, which you can do, you can go down to the court records and look at pretty much anything you want to look at. It's kind of scary. That's how, people find out about auto accidents, and, when people die, that's why people start getting all of these postcards saying, hey, can I buy your house? I'm an investor, because they go down to the court records and just comb through it. So. Any other questions? I know it's a cheery topic.
I think you guys covered it really well. And kind of, I wanted to jump in a little bit on the case study that Suzanne talked about with Alan, because if somebody ends up in the hospital and guardian's not in place, people end up being in the hospital for 30, 60, 90 days longer when they don't need to be in the hospital that long, and they end up not making any improvement physically or mentally, whatever the case may be. So you don't want to be in that situation either, where you're stuck in the hospital with no way out because you haven't had these documents in place.
Very good point, Bess.
Teresa asked about Medicaid planning.
So Medicaid planning is a full webinar of itself, but I can give it to you in a nutshell if that's okay, time-wise. And my firm does do a monthly long-term care webinar about Medicaid. So that's always a free thing that you can do. But Medicaid, basically, to qualify for Medicaid in the state of Oregon, and this is the simplest way to put it, you need to be sick and broke. And that sounds terrible, but it's really the truth. Teresa's laughing at me. So when I say sick, it means that you need to require assistance with activities of daily living. So that's toileting, different types of elimination, bathing, mobility, medication management, eating, basic hygiene, bathing, and you need to require a certain level of assistance with those, and they have basically assign points as they're evaluating the person. So I can't help somebody qualify if they're not sick enough for Medicaid. on the other side of it, there's the three aspects. The first is the medical. The second two, the first is income. Your income needs to be less than $23.82 a month, and that's from things like Social Security, pension, things like that. That's not if you are receiving money from like an investment. If you're receiving money from an annuity or your IRA, that doesn't count as income. That actually is an asset, which is in the different categories. But if your income is over $23.82 a month, that is something that we can help you with, because we do something called an income cap trust, which goes way deeper than we're going to go today. But it basically is an exception to the rules if we create an income cap trust and your income goes into that, and then it's dispersed according to however the DHS caseworker decides your liability needs to be done. Which I can usually come pretty close to it. And then the other area is, and that's just on the person going into care's income. It is not a married couple's income. It's just the one person. So if just husband is going into care or just wife is going into care, it's their income. It's not both of their income. The other thing that we can do is help preserve some of that person's income for the well spouse, person who's going to be staying at home or out in the community. The third area for Medicaid qualification is assets. Assets is where things get sticky. If you are a single person, you can have $2,000 in assets and that's it. That means any sources, that means IRAs, 401ks, bank accounts, checking, savings, anything, $2,000. You can have a house if you are either going to be staying home and receiving Medicaid benefits as far as having in-home care come in and help you, or if you plan to return home. You can have one vehicle if it's something that you're still allowed to drive. Most of the time though, if you need that level of assistance with activities of daily living, you probably can't drive. If you are a married person and you have one spouse going into care, the spouse going into care can keep $2,000 in assets. The well spouse can keep half of their assets, their combined assets, and that doesn't mean joint. Means if it's in his name, her name, it doesn't matter. Everything you both have is counted together. Your house is exempt, one vehicle is exempt. The well spouse can keep half of the assets up to $130,380. If your half of your assets is less than $26,076, you get to keep all of that amount. As I said, it's really involved. This is a big part of what I do personally as an elder law attorney. I help people qualify for Medicaid on a very regular basis. We help with the application, we help with the spend down, and then we also help preserve assets. So if somebody does have more than $130,380 and they don't know how they want to spend it down, we can walk them through that. You do not want to give anything away, and Medicaid does do a 5-year look back. So if you apply for Medicaid tomorrow and 4 years ago you gave a car to your grandson, that's going to count in the look back and it could be a penalty. The current penalty divisor in the state of Oregon is $9,551. So every $9,551 you give away is 1 month that you don't qualify for Medicaid after you're otherwise qualified. That's a nutshell, and I talk fast. So I'm sure there's probably questions on that one, but if you have something I can handle quickly, I'm happy to, but I don't think we're in a huge rush. I know we have another meeting for the council at 5 o'clock, but if you have a question there, I'd be happy to answer it.
If I have a quick question on, you said you can't help people qualify for the sick part.
Right.
A lot of times I, as an OT, would be involved with somebody who's qualifying for their long-term care plan or realizing that their long-term care insurance could be helping them now. And what they always say is, well, I don't need any help with those things. I don't need help getting dressed. I don't need help showering. And I look at them and go, just because you don't have that help doesn't mean you don't need that help or shouldn't have that help. So
Exactly.
Does supervision or like a recommendation that they should have help for safety, does that play in there at all with, you know, not just what they have now, but what we want them to have?
Right. So I'm going to use the favorite attorney's answer. It depends. Suzanne was already laughing before I started saying it because she's heard that a bunch. So it depends. So, and when I say I can't help you, I can't say, okay, Melissa, you know what? I'm going to come out there and smack you in the knee. And so now you can't walk. I can't help you get sicker. I can talk to you and your family about the best way to talk to your caseworker when they do your medical evaluation. It's called a CAPS assessment. And so when that person is coming out with either talking to you in person or on the phone, and I'm going to say oftentimes it's older men because we've got a little ego pride thing going on, and the caseworker calls up to do the medical assessment and says, hey, Bob, how are you doing? I'm doing good. What do you want? Oh, I'm here to talk to you about, your Medicaid application, and I need to know what activities of daily living you need assistance with. I don't need any help. I do it all myself. That's not the truth. And so that is something that I do help families with, is to talk to, don't let Bob get on the phone by himself with that person, or have a family member there to say, well, Grandpa, you don't take a shower if nobody's home because, you've fallen 3 times, or, well, you're right. You don't need help when you've got your walker, but if you fall, you can't get up by yourself. That's a mobility issue. If that happens 3 or 4 times a month, then that's something that somebody might qualify on the mobility aspect of it. I can feed myself. Well, you can, but you're going blind and you can't get the food on your fork. I've actually had that happen recently. You can't cut your meat. You need help with those things. And it's really hard. And it's also what I find, it's really hard for, my parents are 80 and 81. It's hard to see your parents get older, and then it's harder for your parents to ask for help. My parents are in great health, but it is difficult, and they don't want to say, yeah, Dad, you do need help. And Dad, no, I don't. And you don't want to go to your dad and say, yeah, you need somebody to wipe your butt. You don't want to have to do that, but it is something that, if people do need that level of care and they need that help, that's what's going to qualify them for Medicaid. I did just have a case where somebody called me and they're like, my dad got denied for Medicaid. I can't understand why. I'm like, well, it says that he doesn't need assistance with activities of daily living. Well, but he does. He needs a ton of help. I'm like, well, how did they evaluate him? Well, somebody called him and talked to him. Was anybody else present? No. Did they, did you talk to Dad about it ahead of time? No. Is your dad the kind of person that's going to say, I don't need any help? And they go, yeah, probably. And so they got denied. So they're going through an appellate process right now because they let the time lapse before they could get a reevaluation. So it's important to have somebody help you through the process, even if it's something that you want to do on your own or your family wants to do for you and you don't want to pay somebody to go all the way through the process. It's worth paying to have an intake done, at least to get the guidelines for it. And I really like doing it. I really enjoy helping people, and I do a little happy dance. I dance in my office for 2 reasons. One, when I sit still too long, my light goes out and then I have to do my crazy arm dance to get it back on. And the other is when I get somebody approved that I thought was going to be really tough. Then I do a little dance. The dances look completely different and you're not going to see the other one.
Do you do anything in California, Jennifer, or are you primarily Oregon?
I'm only licensed in the state of Oregon, but I do know some elder law attorneys in California and Washington that I can refer people to. And I have a resource where I can find people in other states too. I know some really good ones in Florida too. So, any other questions? And Medi-Cal is a big difference in qualification than qualifying for Oregon Medicaid. The Medi-Cal is a different animal altogether.
Well, I think definitely we'll have to do a Medicaid planning webinar in the next year, because there's all sorts of questions about that.
There's always questions about it.
Yeah.
And I do have to say my disclaimer, this is for informational purposes only. This is not legal advice. All of the numbers I gave you could change. We just had numbers change July 1st on qualification. So it is an ongoing moving target. So
Yeah. Well, thank you both, Jennifer and Suzanne. That was super helpful. You presented everything really clearly, and I hope that the individuals that registered benefited from it. I told you beforehand that there was going to be a survey, but the survey link is not working. I'm so sorry. But I do have everybody's contact information when you registered. So if you do want us to reach out to you, or you can contact us on our website, and we can, if you have more questions, we can have one of the council members reach out to you directly. So just, either in the chat box or, like I said, on our website, let us know if you have more questions that you'd like us to address with you. And then I also put the link in the chat box for our next webinar. So it'll be October 7th, same time, 4 p.m. And Nora King, our Medicare specialist, she's going to be delivering the information on understanding your Medicare options. And it's going to be really perfect timing because Medicare open enrollment starts in October. So it'll be a good chance to get some clarification on what your options look like, how to utilize those benefits to the best of your ability, and get some of your questions answered. So before I let everybody go, I just want to make sure, do we need to follow up with any of our guests here today, or you're good? Well, we hope that you register for our next event, and we can't thank you enough for joining us today. Thank you.
I do just want to throw out there that if you do want a 30-minute free consult with me, you can reach out to the Portland Elder Council and they could connect you with me, and I will let you schedule a free 30-minute consult. So
yeah, we're happy to connect you with our individual council members based on what you need. Thank you, Jennifer.
you're welcome.
All right. Well, I think with that, we'll end the recording, and we'll thank you all for joining us, and have a great evening.
Very good.
Bye, Teresa. Bye, Marilyn. Bye, Kathy. Thanks for